The question in Ramos v. Louisiana is whether the Sixth Amendment's requirement that all jury verdicts be unanimous is fully applied against the states. At the federal level, the courts have long held that unanimous juries are necessary, but due to a somewhat idiosyncratic opinion from 1972, this requirement hasn't been applied against the states. The petitioner in this case is Evangelisto Ramos, who was convicted by a non-unanimous jury, and the respondent is the state of Louisiana. The facts of this case arise out of the murder of a woman named Trinice Fettison. Mr. Ramos maintained that he had nothing to do with the murder of Ms. Fettison. A jury convicted him of that murder with 2 jurors dissenting. Essentially, it was a 10-2 jury verdict against him. 2 of the jurors would have held that the state had not shown his guilt beyond a reasonable doubt. The question before the court is whether it was constitutional to convict Mr. Ramos of second-degree murder without a unanimous jury, whether it's permissible to ever convict a criminal defendant without the full unanimity of all jurors. So it has long been understood that the Sixth Amendment in federal cases requires unanimous jury verdicts. The Sixth Amendment states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. The Sixth Amendment itself does not specifically say that jury verdicts have to be unanimous, but this was certainly the background understanding of what the jury trial itself was when the Sixth Amendment was passed. The Supreme Court's incorporation doctrine essentially states that those provisions of the Bill of Rights applicable against the federal government are also applicable against the states as the essential components of the liberty protected by the 14th Amendment. The main prior case at issue here is Apodaca v. Oregon, a 1972 decision, which is one of the few, and actually perhaps only, instances in which a provision of the Bill of Rights was applied against the states, but in a different manner than it applied against the federal government. So the question in that case was whether it was constitutional for Oregon to convict someone with only a 10-2 verdict. And the outcome in that case is somewhat peculiar because 8 justices agreed that the Sixth Amendment right to a jury trial should apply against the federal government and the states in the same manner. But 4 of those justices thought that unanimity was never required, and 4 of those justices thought that unanimity was always required. So the deciding vote in that case came down to Justice Powell, the swing justice of his day, and he alone said that he thought unanimity was required against the federal government, but not against the states. And despite the fact that he was the only justice who held that opinion, because he was in the center of a 4-1-4 split, his opinion essentially became the controlling opinion from that case. The ultimate question here is whether that opinion, that concurrence from Justice Powell, should continue to be controlling or whether that should be reconsidered. Ramos's main argument is that the unanimous jury requirement is a core component of the Sixth Amendment and that ought to apply equally against the states as it does against the federal government, and therefore that his conviction, which was not unanimous, was unconstitutional and needs to be reversed. Louisiana argues 2 things in this case. First, it argues as a threshold matter that the Sixth Amendment in and of itself actually doesn't require a unanimous jury. But moreover, Louisiana also argues that even if the Sixth Amendment requires unanimity at the federal level, as a matter of stare decisis, the Supreme Court shouldn't reconsider Apodaca and should permit states to continue to operate with the possibility of non-unanimous juries.